Can you handle the stress of a personal injury lawsuit? Do you know the steps you will have to go through if you want to file a lawsuit? Knowing the process itself, the steps and procedures can be incredibly helpful and alleviate most of that stress. This journey, often seen as daunting, is a crucial step towards reclaiming your peace and justice. It's a process that requires understanding and patience, as it can be intricate and lengthy. Knowing the timeline of a personal injury case can help in managing expectations and preparing for each phase of the journey. Let's start with the pre-litigation phase, the filing of the lawsuit, the discovery phase, pre-trial motions, and trial preparations. It's a lot for those experiencing a lawsuit, but once we understand the process, it's not as overwhelming. Each stage comes with its unique set of challenges and opportunities, and understanding these can equip you with the knowledge to navigate the process more effectively. The journey to getting your lawsuit settled begins long before you step into a courtroom. This is the pre-litigation phase. It all starts with you consulting an attorney who will guide you through the procedures. Your attorney is also the person that should be honest with you from the beginning, letting you know if you truly have a case, and if not, why not? What factors in your case make it something they feel is one that could win and result in a settlement? There are numerous questions to ask an attorney before hiring them. Make sure you watch our video, the 10 questions to ask your personal injury lawyer before signing on with them, if you haven't yet hired someone to represent you. We will have the link in our description. You and your attorney will review evidence for your case. This may include medical records, witness statements, or anything that bolsters your claims. Yet, the pre-litigation phase isn't just about building a strong case. It's also a time for negotiation with the insurance company. Your attorney will enter into talks with the aim of reaching an acceptable settlement offer. This can avoid the need for a lengthy court trial, but it's a delicate balancing act. The attorney must weigh the advantages and disadvantages of settling against the potential outcome of a court case. During this time, you and your attorney should have an understanding of what you are and are not willing to accept if a settlement can be reached. Once the decision is made to proceed to litigation, the next stage begins. It's time to file the lawsuit. Filing a lawsuit starts with drafting a formal complaint. This document sets out the legal grounds for your claim and the damages you're seeking. It tells your story, explains how you were injured, and why you believe the defendant is responsible. The complaint must be filed with the court and served to the defendant, letting them know they're being sued. They typically have a set amount of time, usually around 30 days, to respond to your complaint. This response, called an answer, outlines the defendant's defenses and counterclaims. The elements of a personal injury claim usually include duty, breach, causation, and damages. In simpler terms, you need to prove that the defendant had a duty to act or not act in a certain way, that they have breached their duty or inaction that caused your injury. With the lawsuit filed, we move into the discovery phase. This phase is all about gathering information. It's a pivotal part of any personal injury lawsuit, where both sides exchange information and evidence relevant to the case. Picture it like a strategic game of chess, where each player learns about the other's game plan. The goal is to arm themselves with as much information as possible before heading to trial. This process could be very lengthy. Depositions, for example, involve face-to-face questioning under oath. Interrogatories, on the other hand, are written questions that require written answers. Then we have requests for production, demanding documents or other physical evidence, and requests for admission, asking one party to admit or deny specific facts. Expert witnesses often step into the spotlight during this phase. It is important to remember that all of these actions can be very expensive. You may have an attorney who is only charging you fees if you win, but they will deduct these expenses if you are awarded a settlement, reducing your net amount. This discovery phase is a key component in shaping the trial's outcome. If you have not settled by this time, you will then enter into the next stage of pre-trial motions. What are pre-trial motions and what happens during this phase? Pre-trial motions are essentially requests made by either party to the court to resolve certain issues before the trial. These motions can be categorized into two groups: dispositive and non-dispositive motions. Dispositive motions aim to dispose of some or all of the claims in the case. For example, a motion to dismiss or a motion for summary judgment. On the other hand, non-dispositive motions deal with more procedural matters, such as a motion to change venue or a motion to exclude evidence. It's important to understand that these motions can significantly influence the outcome of the case. It's important that your attorney explains this stage of your lawsuit to you and review the important points of your case. They can determine what evidence is admissible, where the trial will be held, and even if the case proceeds to trial at all. They're a strategic tool used by attorneys to shape the landscape of the trial. With pretrial motions handled, it's time to prepare for the trial. If you've gotten to this point, you and your attorney will have discussed possible witnesses, medical professionals, and documents that will be shared with the jury during your trial. The opening statement of your trial sets the tone, while the closing statement is the final chance to persuade the jury. There are also numerous other factors and considerations that come into play during trial preparation. Deadlines must be strictly adhered to, the evidence must be thoroughly reviewed, the schedule must be managed efficiently, and there must be flexibility to adapt to any unexpected developments. Every case is unique. Clearly, settling early on is less expensive for both sides, but you also do not want to be talked into or feeling coerced into settling because it's the easy way out. Very often, people settle early on because of the stress and fear of the unknown. Knowing what the process is, procedures and expectations of the court will help you with your confidence to move forward and making decisions based on the case itself. Personal injury cases can be settled in a month or linger on for years. Understanding the legal process itself and ongoing communication with your attorney is key for a successful outcome.